from the very beginning, we've talked about licensing and the benefits of licensing for, all of the different shareholders that work here. But where does that licensing come from? What's the basis for it? And coming into a licensing deal, you understanding basic trademark licensing law is critical. And Bruce and I are U.S. attorneys, so our focus is on U.S. law. But it's important to understand the laws of all the relevant countries and jurisdictions at play. And it's also very important to leverage relationships with attorneys in those other jurisdictions. INTA, in particular, the International Trademark Association, is something that we're members of and gives us a great ability to interface with attorneys around the globe to discuss the different issues. You do not want to fall into the mistake that a trademark here is good everywhere, or what applies to trademarks here applies everywhere. Trademark protection generally stops at the borders, and understanding how to leverage other jurisdictions is key to really strong licensing deals. And licensing involves several areas of law. So a lot of people get in on the party here. You have trademark law, contract law, antitrust issues. You don't want to end up with licenses that violate antitrust laws, and also franchise issues, impacting franchisees or accidentally creating a franchisee situation where you didn't want it. All of these laws work together for the umbrella concept of licensing. Trademark licensing is ultimately a contractual relationship under which a trademark owner grants another the right to use a mark subject to the terms of the contract. I promise there won't be too many more reading from Black's Law Dictionary, but it's important to know just flat out, what it is and what it is not. Trademark licensing is not an assignment. It's very important because assigning a trademark transfers the ownership and associated goodwill of a trademark, which is essentially a complete transfer of the trademark. And if your licensing agreement isn't drafted properly or followed properly, you can end up in a situation where you've accidentally assigned your trademark, and all of a sudden you are out of luck and your IP is flown the coop. Now, historically, a major issue with licensing was that trademarks were always understood to function as the indicator of the source or origin of the goods. It goes all the way back to them being maker's marks, where a blacksmith would imprint their mark on a horseshoe. So you know that this horseshoe came from, Eli the blacksmith, 2 doors down from the tavern. And it was personal to the individual and eventually the business. And someone else using that mark is inherently an infringer. Whether you agree with it or not, it's someone else using your mark, so it's a false designation of source. The Lanham Act, which was passed in 1946, actually codified some of these concepts and facilitated the growth of trademark licensing. Introduced the related company doctrine, which allows the owners of IP to permit third-party use as long as they control the nature of the use, and critically important, controlling the quality of the products or services that are produced under that mark. And this allows that use to inure to the benefit of the trademark owner rather than the third party, which is really one of the most important functions of trademark licensing, as we'll get to. As I said, legitimate and controlled use by a related company inures to the benefit of the trademark owner, which really means that if a third party is using a trademark under an appropriate license, then that trademark is being used properly. And use in commerce is a critical component of trademark prosecution that we'll get to shortly. But in order for a license to be valid and for that for that use to be legitimate and controlled. The most important issue is that the mark owner has to control the quality of the goods and services. As it says right here, quality consistency ensures that consumers can rely on the mark's goodwill. If you are not monitoring the quality of the goods or services, then that goodwill can be damaged. And it may be found that you're engaged in naked licensing. That's what it sounds like. You are just licensing the mark away, collecting your royalties, and sitting back. Now, that might sound good in the short term, but in the long term, what that can result in is the mark being canceled or deemed abandoned. Third parties can petition the U.S. Patent and Trademark Office to cancel your mark. Court action can result in your mark being lost. Even an intrepid examining attorney at the USPTO can look at your statement of use and send out the dreaded request for information. And as soon as that rabbit hole gets opened, you better hope that your license was drafted properly.